Well, good afternoon for those of you joining us from the East Coast of the United States, and welcome to today's installment of our ongoing series exploring the amendments to the United States Constitution. My name is Samuel Holliday, and I have the tremendous privilege of serving as Director of Operations and Scholarship for the United States Capitol Historical Society. And we're honored that so many of you have taken time out of your busy day, be it early in the morning or late in the evening, depending on where you're joining us, to participate in this discussion and this ongoing course of study that we've charted out for our coming months and perhaps even years. Before we get started with today's fantastic program and our distinguished scholar, I'd like to do a little bit of technical housekeeping. We've come to really enjoy using this Zoom webinar platform to bring these discussions to you nationwide and worldwide. And we can interact in some really helpful ways. If you have any technical difficulties during the course of today's program, if you think you're having trouble seeing or hearing us throughout the course of the day, you can submit those troubleshooting issues in the chat section of the webinar, and I'll work with you in real time in the chat. Now, if you have any content questions for Professor Chemerinsky, you can put those into the Q&A section so they can be posed at the end of the presentation. So once again, any troubleshooting can go in the chat. Any content-based questions can go in the Q&A section. It's now also my great pleasure to introduce the President and CEO of the United States Capitol Historical Society, Jane Campbell, who will introduce Professor Chemerinsky and start today's program. And she will be joining us here in just a moment to get this started. Jane?
Thank you so much, Sam, and welcome all. We are delighted to have you with us, and I will tell you that we know that those of you who are tuned in on the Thursday before Labor Day are our most dedicated listeners. We want to welcome you to our series on the amendments to the United States Constitution. The history of these amendments, what was going on at the time they were adopted, and how these amendments have influenced our lives over the years. As we move into this series today, we're discussing the history and the societal impact of the Fourth and Fifth Amendment. Now, we've all heard about an accused person who takes the Fifth. Today, we're going to look at how that amendment came to be. Much of what separates the United States from other nations are our laws, which are meant to protect the rights of the innocent above all. To safeguard that principle, the first Congress passed the Constitution's Fourth and Fifth Amendment to protect Americans from unreasonable search and seizure and to ensure them due process of law and other vital liberties. Among the topics that we're going to discuss today are the legal abuses in British America that inspired the framers to create the Bill of Rights, the ways in which our laws and judicial rulings have changed in the interpretation of the Fourth and Fifth Amendment, and we'll also try to seek an answer. In what ways is the American criminal justice system still a model for the world? And do our protections equally apply to all Americans, especially as we look at the increased scrutiny over police procedure? Our featured guest for this timeless conversation is the president of the Association of American Law Schools, Professor Erwin Chemerinsky. Professor Chemerinsky is the Dean of the University of California, Berkeley Law School, receiving his Juris Doctor from Harvard Law. And according to one study, he is the most cited legal scholar in the United States. He's an author of more than 200 law review articles, 14 books, and we are honored to have him with us today. Professor, tell us about the Fourth and Fifth Amendment.
Thank you so much for the kind introduction. Thank you for inviting me to speak today. The Fourth and Fifth Amendments are enormously important as ways of limiting police abuses. What's interesting when I was thinking about this topic, talking about the history of the Fourth and Fifth Amendments, is how there are almost no Supreme Court cases about them for the first century of American history. As was just pointed out, they were adopted in 1791 as part of the Bill of Rights, but you really need to get into the late 19th century before you get Supreme Court cases about the Fourth and Fifth Amendments. It's worth at the outset, since we're focusing on history, to think about why. There was very little in the way of federal policing until the beginning of the 20th century. It was really prohibition that caused the first federal police to develop. And over the course of the 20th century, we had the FBI, we had the Bureau of Narcotics, with the Border Patrol, and many others. But those didn't exist in the 19th century. And it's also important as we think about history to keep in mind that the Bill of Rights didn't apply to state and local governments in the 19th century. In fact, in the 1830s, the Supreme Court, in an opinion by the great Chief Justice John Marshall, said that the Bill of Rights was meant just to be a limit on the federal government. And it wasn't until after the ratification of the 14th Amendment in 1868, and it really wasn't until the 20th century that the Supreme Court began to say that the Bill of Rights are part of the liberty protected by the Due Process Clause and safeguarded from state interference. Well, if there wasn't much in the way of federal policing, and if the Fourth and Fifth Amendment didn't apply to state and local governments, it shouldn't be surprising that from a historical perspective, you don't get cases about them until really the 20th century. And then you have the body of law that we deal with today. And I do want to talk a bit about how it's developed. Well, let me talk first about the Fourth Amendment, its history and the development of the law, and then about the Fifth Amendment. Whenever I teach about a constitutional provision, and this semester I'm teaching both a law school and an undergraduate class, I always start by reading the constitutional provision to the students, because that has to be our touchstone. The Fourth Amendment says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Why is there the Fourth Amendment? It's part of the Bill of Rights. In England and in the colonies before the Revolutionary War, there were called general warrants. The police could get a warrant from a judge to search every house in a neighborhood, to look for contraband or look for a fleeing felon. The framers of the Constitution were angry about this idea of general warrants. They certainly had in mind the notion of privacy. And so the core of the Fourth Amendment, as the Supreme Court often has said, is a requirement for individualized suspicion. In order for a person to be searched by the police, in order for property to be seized by the police, in order for a person to be arrested, seized by the police, there has to be reason to believe that that person has committed a crime, or there's evidence of a crime. It's about individualized suspicion. And the Fourth Amendment says that in general, there should be a warrant, and it should be based on probable cause. The idea was, we can't just trust the police. They have their own self-interest. They can be, though well-intentioned, overly zealous. And so by requiring a warrant, the framers of the Fourth Amendment thought there'd be a check on police behavior. Let me talk about two developments with regard to the Fourth Amendment historically, putting in the context that I just described. One is the fascinating question of what is a search? Notice the Fourth Amendment applies when the police search. But what's a search? I'm actually teaching criminal procedure investigations this semester, and I spent the first couple of weeks of the semester just focusing on this question of what's a search. I was talking just yesterday in class of if police put a camera on a utility pole and monitor people's behavior in the area 24 hours a day, 7 days a week, is that a search? Does that require a warrant based on probable cause? Or yesterday we were talking about if police go through somebody's garbage that's put out on the street, trash collection, is that a search? On Monday, we're going to talk about if police use drug-sniffing dogs, is that a search? Well, it's interesting, historically over the course of American history, the court has taken three different approaches to defining what's a search. The first came in 1928 in Olmstead versus United States. It was a case arising out of prohibition. The federal law enforcement were particularly suspicious of Roy Olmsted, who was a known bootlegger. And so in order to get the evidence that he was violating prohibition, they wanted to tap his phone. And the way they did this was to put the wiretap on the phone lines outside of his business, outside of where he lived. And the question was, if the police engage in wiretapping without trespassing onto someone's premises, is that a search within the meaning of the Fourth Amendment? And the Supreme Court said, no, it's not a search unless there's a physical trespass. Chief Justice William Howard Taft wrote the opinion for the court. He's the only person to have ever been both president of the United States and a justice of the Supreme Court. He was truly a larger than life figure in every way. But he said, in order for it to be a search, the police have to trespass onto the property. And if they can gather the information without entering the property, it's not a search. Justice Louis Brandeis, one of the great justices in all of American history, wrote a powerful dissent. And he said, the Fourth Amendment should be seen as about the right to privacy, the right to be let alone. And he said, it shouldn't matter whether the police trespass or not. Either way, if they're wiretapping, listening to a private conversation, that's a search. Olmsted was the law for almost 4 decades. And so long as the police could gather information without trespassing onto property, it wasn't a search. One famous case involved police put a listening device on the wall, but in a different place than where they wanted to hear the conversation. It was a different office. And the court said, no, they didn't trespass, so it's not a search. This changed in 1967 when the court took a different approach. The case was Katz versus United States. Charles Katz was a known major gambler. He ran a major operation with regard to gambling on college basketball. He lived in Los Angeles, and he would go each day to phone booths on Sunset Boulevard to engage in his gambling activity. When I teach this case, I always have to be sure my students still know what a phone booth was. Well, what's involved here is that the police blocked off one of the phone booths at the location, saying it was out of order. So he had to use the other one. And then they wiretapped the conversation. Now, no trespass was involved onto Katz's property. Katz argued in court that this violated his Fourth Amendment rights. But the lower court said no. The lower court said, based on Olmsted, no trespass, therefore there's no search. But the United States Supreme Court reversed. The Supreme Court said the Fourth Amendment is about protecting, quote, the reasonable expectation of privacy. The court said it will look to whether someone subjectively has shown an expectation of privacy and whether objectively it's one that society should recognize. So wiretapping is inherently a search, even if it doesn't trespass onto somebody's property. And the Supreme Court applied this in some instances to find that there was a search. In one case, the Supreme Court said, if the police point a thermal imaging device at a home and measure where the heat is coming from to see if there's a marijuana growing operation, there's a lot of heat, that's a search. But in another case, going back to an example I mentioned, the Supreme Court said going through somebody's trash that's left out on the street is not a search. The police don't need a warrant based on probable cause because we don't have a reasonable expectation of privacy when we throw out garbage and leave it out on the street. Well, the court adopted a new approach just in 2012, a decade ago, in a case called Jones versus United States. Antoine Jones was suspected of cocaine trafficking. The police went to a judge and got a warrant to put a GPS device on his car. The warrant said it had to be placed on the car within 10 days of the issuance of the warrant, and it had to be put on the car while it was parked in the District of Columbia. Inexplicably, the police waited until the 11th day to put the GPS device on the car, and they put it on the car while it was parked in Maryland. For 28 days, they tracked the movements of Jones' car through the GPS device. And he was prosecuted for cocaine trafficking. The GPS logs the key evidence against him. The question was putting the GPS device on his car a search within the meaning of the Fourth Amendment? The government said he has no reasonable expectation of privacy when he's driving on public roads. That's there for the world to see. Is interesting, at the oral argument, at one point, Chief Justice Roberts said to the attorney for the United States, "Are you saying the government could put a GPS device on the bumper of my car without a warrant?" Justice Kennedy then interjected, "Are you saying the government could slip a GPS device in my pocket and follow me around?" I then knew it was all over for the United States government, because I've always predicted that the justices are most likely to find it be a search if they could see it happening to them. 9-0, the Supreme Court said it was a search. Justice Scalia wrote for the court and said, putting the GPS device on the undercarriage of the car was a trespass. And the court said now it's a search if either it's an intrusion onto property or it's an invasion of the reasonable expectation of privacy. So let me tell you about the most recent Supreme Court case with regard to this issue. It's a search. It's a case called Carpenter versus United States from 2018. What's involved here was Timothy Carpenter was suspected of a number of burglaries, robberies of stores, especially Radio Shacks and T-Mobile stores. And again, I always make sure my students remember what a Radio Shack used to be. The police went to Carpenter's cell phone company and got his cellular location information from 127 days. Every time our cell phone is on, it automatically connects to cell towers. And the cellular location information can tell a great deal about where we are at any moment in time. And this was the key evidence against Carpenter. And the question was, did the police need a warrant based on probable cause to do this? And the Supreme Court 5-4 said yes. That the court said to get this information, 127 days of cellular location information, could reveal a great deal of, quote, the privacies of life about Carpenter. You could see what doctors he visited, where he went to worship, who he went to see. And so the Supreme Court said, because it's gathering so much information, it's an invasion of privacy. Well, what about the example I mentioned earlier? A poll camera, 24 hours a day, 7 days a week, monitoring a public area. The lower federal courts are split as to whether that's a search. It's not an intrusion onto property rights, but doesn't invade the reasonable expectation of privacy. I want to talk about one other development with regard to the Fourth Amendment, and that's stop and frisk. I read to you the language of the Fourth Amendment that speaks of probable cause. And what's interesting is the Supreme Court has said that police can stop an individual and frisk an individual without needing probable cause, with just reasonable suspicion. The case was Terry versus Ohio in 1968. A police officer in Cleveland saw two men pacing up and down on a public sidewalk. He said he was suspicious. He thought they were casing the joint. Now, keep in mind, what they were doing was legal. They were just walking up and down the public sidewalk. But he took the two men and he detained them. He frisked them. And he found that one of them, Terry, had a gun that he wasn't legally allowed to have. Terry was prosecuted for illegal possession of a gun. Terry said, the police didn't have probable cause to stop me. The police didn't have probable cause to search me. The evidence should be excluded. But the Supreme Court, in an 8-1 decision, ruled against Terry. I don't think it's a coincidence that the officer was white and Terry was black. Chief Justice Warren wrote the opinion for the court. Only Justice Douglas dissented. Chief Justice Warren said, if police have reasonable suspicion that somebody commit a crime, they are allowed to stop the individual. And if the police have reasonable suspicion that somebody has a weapon, they're allowed to frisk the individual. It doesn't take probable cause. The NAACP Legal Defense Fund wrote a brief in the case of the Supreme Court saying, this is going to increase racialized policing. Police are going to use this discretion so as much more to stop people of color and frisk people of color. And studies have been done in every major city that document exactly that. Holding all else constant, people of color are much more likely to be stopped and frisked by the police because of Terry versus Ohio. In fact, the Supreme Court has made it easy for the police to stop almost anyone at any point in time. I'll talk about another Fourth Amendment case, Wren versus United States from 1996. Some undercover police officers in Washington, D.C. were driving in what they called a, quote, high crime area. That's a euphemism for a community that's largely individuals of color. The police said they saw a car stop at a stop sign for an unusually long period of time. They said it stopped at the stop sign for about 20 to 25 seconds. They were then suspicious of the car, and so they followed it until the car violated a traffic law. The driver turned without a turn signal. The officers pulled over the car, ordered the driver and passenger out, searched the area they were, and found illegal drugs. Well, there's no doubt that the traffic stop was a pretext. After all, in DC at the time, undercover police officers were prohibited from enforcing traffic laws. Nonetheless, the Supreme Court said the evidence could come in. The court said it doesn't matter what's the subjective motivation of the officer. So long as the officer has reasonable suspicion, that's enough for the stop. I talked to a police officer who told me if he follows any car for about 15 minutes, he'll find a traffic violation. Changing lanes or turning without a signal, going a mile over the speed limit, not stopping long enough at the stop sign. And so Terry versus Ohio lessens the standard for a stop from probable cause to reasonable suspicion. Wren makes it so much easier to find reasonable suspicion. And we know that the police use this in a very racially discriminatory way. Well, let me talk next about the Fifth Amendment. There's a great deal in the Fifth Amendment, and I want to talk about only one clause in the Fifth Amendment. What we commonly refer to is the privilege against self-incrimination. And this is found about 3/4 way through the Fifth Amendment, where it says, nor shall any person, quote, be compelled in any criminal case to be a witness against himself. Nor can any person be compelled in any criminal case to be a witness against himself. This has been interpreted by the Supreme Court to say, no person can be required to make any statement that would be incriminating. And so when it was referred to in my introduction about taking the Fifth Amendment, that's what it's about. The person says, I'm not going to answer these questions because they might be incriminating. Historically, where does this come from? It actually long predates the United States. One can find in the Torah indications that people should not be forced to be a witness against themselves. One can find in English law, long before the United States, protections against people being witnesses against themselves. This idea was not an American development. Why did it come to be that people should not be witnesses against themselves? I think some of it is about the fear of coercion, that when police question people, they can coerce them, and that sometimes this leads to false confessions. The Fourth Amendment isn't really about protecting the innocent. It's much more about our privacy. But the privilege against self-incrimination is about protecting the innocent. There are many instances that we know of where innocent people ended up confessing to crimes that they didn't commit. And so it's about lessening coercion. There's also a notion of privacy, that our thoughts are private and we shouldn't be forced to express them. There's a strong dignity notion to the privilege against self-incrimination. That's an affront to dignity to force a person to make statements that would incriminate himself or herself. Now, in the most limited sense, what this says is that a prosecutor can't introduce evidence against somebody at a trial if the statements were gained in violation of the privilege against self-incrimination. The Supreme Court has gone further, and since the 1930s has said that this requires that any statements introduced into evidence be voluntary. That if a statement was gained in an involuntary manner, it violates the privilege against self-incrimination, and thus it can't be introduced into evidence. And there are Supreme Court cases, lower court cases, involving people who were literally beaten by the police until they confessed, people who were tortured until they confessed, people who were threatened until they confessed, people who had family members who were threatened until they confessed. And what the Supreme Court would say in all of these instances is they're not voluntary. And since they're not voluntary, it violates the privilege of self-incrimination. And there's a large body of law as to what's voluntary and what's not voluntary. Obviously, physical force would make it involuntary. Certain psychological coercion, like threatening somebody's family member, would make it involuntary. Interestingly, the police lying to someone to get an incriminating statement does not make it involuntary. So imagine that the police arrest somebody and say, somebody else has confessed to the crime and pointed the blame on you. Or somebody else has said you're responsible, or your co-conspirator has already confessed. Imagine all of that's lies. And then the police get an incriminating statement from somebody. The Supreme Court said even though it was induced by lies, it's still voluntary. And I think it's an interesting question of, should it be regarded as voluntary? One of the most important Supreme Court decisions about the privilege against self-incrimination was Miranda versus Arizona in 1966. It involved a man, Ernesto Miranda, who was questioned at length by the police and made an incriminating statement. The Supreme Court, in an opinion by Chief Justice Warren, said that it is inherently coercive for police to be questioned, for a person to be questioned while in police custody. Chief Justice Warren said that in order to protect against the privilege against self-incrimination, there need to be steps taken to lessen its inherently coercive nature. And the Supreme Court said, whenever a person in custody is questioned by the police, they need to be given certain warnings. And if ever you watch police shows, you're sure to know those warnings. Person has be told there's the right to remain silent. Anything you say will be used against you. You have a right to a lawyer, and if you can't afford one will be provided. And the Supreme Court believed that these warnings would lessen the coercion inherent to being questioned while in custody. There are a lot of studies that have been done, and they cast doubt on this idea that the warnings really do lessen coercion. The police were initially very much against Miranda warnings, saying this is going to make it too hard for us to get confessions. But the police have seen that it doesn't really decrease confessions. And in a case not long ago, a Society of Police Chiefs urged the court to continue Miranda. Why? Well, Miranda says that so long as police give these warnings, there's a presumption that any confession is voluntary, and that works to the benefit of police. I'll just conclude before turning to questions by telling you about a Supreme Court case from June 23rd this year concerning Miranda. Here's the issue. If police violate Miranda, they don't give the warnings as required, can the police officer be sued for money damages? The case was Vega versus Tico. I should disclose that I was co-counsel in the Supreme Court for Terrence Tico. Tico was a nurse attendant at a hospital in Southern California. A woman on awakening from anesthesia after an emergency heart proceeding said that Tico had touched her sexually in an inappropriate manner. The hospital called the Los Angeles County Sheriff's Office. They sent out a deputy sheriff, Carlos Vega. Vega took Tico into a small room to question him. I don't think there's any doubt that Tico was in custody at that time. Somebody's in custody if a reasonable person wouldn't feel free to leave under the circumstances. Vega questioned Tico in a very aggressive, intimidating way, threatened to deport him, among other things. Tico said he would apologize to the woman. Tico was criminally prosecuted in California State Court. He was acquitted. The jury found him not guilty. He then sued the police officer for questioning him while he was in custody without giving Miranda warnings. But the Supreme Court ruled 6-3 that the police cannot be sued for failing to give Miranda warnings. Justice Samuel Alito wrote for the court. Justice Elena Kagan dissented. So that's a quick overview with regard to the Fourth and the Fifth Amendments. There's certainly countless specific issues we can talk about, and I'll turn it over to the question and answers.
Well, we've certainly taken a quick course, Professor. Thank you so very much for your time and your talent. Now, let me just ask a question that's on the minds of many folks. Is you noted that there were no cases in basically the first century of United States government about the Fourth and Fifth Amendment, and then we began to have them. How much of that do you think was related to changing or attempts to change race relations in this country?
I think the reason there weren't Fourth and Fifth Amendment cases during this time was, as I said, there really wasn't federal police, and the Bill of Rights was not yet applied to state and local governments. There's no doubt that race played a great role with regard to policing. The first organized police forces in the United States were slave patrols in the South that existed to round up fugitive slaves. Generally, apart from that, what you had in the first part of American history was a town sheriff or a marshal or a constable, but you didn't have a whole police force. Professional police forces, we think of them today, have their antecedent in the slave patrols and then began to develop after the Civil War. And professionalization of police with things like uniforms and badges and training didn't come until the very end of the 19th century.
And Professor, were there specific cases during the colonial period that motivated the authors of the Bill of Rights to put the Fourth and Fifth Amendment into the Bill of Rights?
It was widely known that the police in the colonies could basically search anyone anytime they wanted. There were general warrants. And that's what the framers of the Fourth Amendment wanted to get away from. The framers of the 14th Amendment wanted to make sure that there was individualized suspicion before a person was searched or arrested. There were particular cases, as English law was changing. There's a famous case called Entic versus Carrington, which was from 1765 in England, which involved the police searching a carriage. And it's one of the first cases to articulate a requirement for individualized suspicion. And the court has often referred back to that in understanding the Fourth Amendment.
And here's a question that is often on people's mind is, so we've all watched Law and Order at least once. Does Law and Order do a fair job of presenting the subtleties of the exclusionary rule, or did they ignore the state of the law in the interest of entertainment?
I have to confess, I've never seen Law and Order, so I'm not the best person
Professor,
to
how
know
can
how
this
Law and
be?
Order does with regard to this. I certainly watched a lot of other police procedurals. I think they vary tremendously with the degree of realism about presenting policing and with regard to the degree of realism with regard to the exclusionary rule. It's interesting. The exclusionary rule is enormously controversial. You refer to it. It says that evidence that's gained as a result of a police violation of the Constitution cannot be admitted against the defendant. So if it's an illegal search, whatever the police get can't be used against the defendant. If it's a confession gained in violation of Miranda, it can't be used against the defendant. But the Supreme Court has relaxed the exclusionary rule. An important case in 2009 was Herring versus United States. And there the Supreme Court said that the exclusionary rule doesn't apply if police violate the Fourth Amendment in good faith or only negligently, carelessly. That the exclusion rule applies only if the police intentionally or recklessly violate the Fourth Amendment. I have not seen in the police shows I've watched, and I obviously don't watch a lot of them, mention of that, which gives much more latitude to the police to be able to violate the Fourth Amendment.
And a couple people, I'm trying to put a couple questions together. What happens when there's an elderly person who, goes in voluntarily, says, of course, I'm going to come and do whatever the police, and they don't really understand that what they say can be used against them. And they may have heard the Miranda writings, but they didn't understand them. Can someone come back later and say, I never understood that? What's the situation with that kind of question?
Generally, the answer to that question is no, that once you've been given the Miranda warnings and you then confess, your statements are admissible. Now, if somebody could show they were not mentally competent, that they did not have the capacity to understand, then that would be different. But if it is a competent adult, it isn't the ability to later say, I didn't understand the warning, so therefore the confession should not be introduced. Same thing if somebody consents to a search by the police, even if they didn't know they had the ability to refuse, even if they didn't understand the consequences, the fruits of that search are still admissible.
Now, two people have asked about the Fourth Amendment, which you introduced as being foundationally a right to privacy. And how does that Fourth Amendment right to privacy impact the constitutional question about abortion and women's reproductive choices?
It's an excellent question. I would think of privacy as potentially meaning three different things. One is freedom from physical intrusion by the government. A second is the ability to control information. And the third is autonomy, the ability to make important decisions about our lives. The Fourth Amendment is about the first two, but not about autonomy in the sense of abortion or reproductive choice. The Fourth Amendment limits intrusion, the ability of the police to enter our premises without a warrant and probable cause, and it protects information. Under current law, the police can't listen into our conversations by wiretapping or read the content of our email without a warrant and probable cause. But the Fourth Amendment's never been thought of privacy in the third sense, autonomy over decisions. But the Supreme Court for a century has said the word liberty in the Due Process Clause protects aspects of privacy and autonomy, and they protect them from government interference. So the Supreme Court has said under the word liberty, under privacy, there's constitutional protection for the right to marry, the right to procreate, the right to custody one's children, the right to keep the family together, the right of parents to the upbringing of the children, the right to purchase and use contraceptives, the right of consenting adults to engage in same-sex sexual activity in private, the ability of competent adults to refuse medical care. All of those are protected under privacy autonomy, but not under the Fourth Amendment, but under the Liberty Due Process Clause. The Fourth Amendment is really about intrusion and control over information.
Now, let's talk about a search that's been in the news lately of President Trump's home at Mar-a-Lago. Several people have maintained that that search in and of itself was illegal. I know you've done an article about that, done some thinking about that. Would you kind of offer your perspective from a legal matter on that?
There's two questions. First, was there probable cause for search? And second, were all of the requirements for getting the warrant and executing the warrant carried out? Those are the only two questions in my mind. The first is, was there probable cause that a crime was committed? We now know that the government thought that perhaps there's been 3 different federal laws were violated by President Trump having highly classified information, Mar-a-Lago, that he wasn't allowed to possess. Some of that material apparently could only be seen in a safe site or very limited circumstances. And so was there a probable cause? The judge found it. From everything we know, the answer is yes. Were the requirements with regard to obtaining and carrying out the warrant met? The federal government went to a magistrate judge in Florida, got a warrant. They submitted the appropriate documents, that have now been made public, though one of them is greatly redacted. From everything we know, they carried out the search in a manner that was consistent with the Fourth Amendment. So I don't see any violation of the Fourth Amendment in anything I've read. Then the question is, should there be different requirements when it's a past president of the United States? And I think the answer to that is clearly no. One of the most important aspects of the rule of law is that no one, not the president, not a former president, is above the law. And if there was evidence that Donald Trump had violated the law, then it was appropriate for a magistrate judge to issue a warrant and for it to be executed.
Well, thank you. Professor, with 2 questions that I'm going to try to put together about the presumption of innocence. One is, what does that really mean, the presumption of innocence? And then taking it to when someone pleads the Fifth, often listeners assume that a crime must have been committed, because if it hadn't been, why would someone plead the Fifth? And so can you talk to us about the presumption of innocence in that context, please?
Sure. We all know the phrase, a person is presumed innocent until proven guilty. And that is a core maxim of our legal system. Now, what it means practically is that a person, in order to be convicted of a crime, must be proven guilty beyond a reasonable doubt. That's a hard standard to meet. It's not no doubt. There's little in this world where there's no doubt. But it's certainly more than, say, a preponderance of the evidence, more than a 51-50, 49 chance. It really requires that the prosecutor, to convict somebody of a crime, prove beyond a reasonable doubt that that person committed the crime. They've got the presumption of innocence. The burden of proof is on the prosecution to be able to prove guilt beyond a reasonable doubt. And there's better to let 100 guilty people go free than to convict one innocent person. And of course, this is because convicting an innocent person, imprisoning, putting them to death is so abhorrent. Well, the presumption of innocence is part of that. Now, the second question that you ask concerns if in a criminal trial, a defendant takes the privilege against self-incrimination, can the jury draw a negative inference from that? And the answer is no. The Supreme Court has held for a half century that if somebody takes the Fifth Amendment or just doesn't testify at a criminal trial, the jury can't assume or draw any inference of guilt from that. And in criminal cases, juries are specifically instructed that they're not allowed to draw an adverse inference, an inference of guilt from a defendant not taking the witness stand. Now, in practical reality, do juries sometimes do exactly that, saying in their own mind, if this was an innocent person, this individual would be on the witness stand. So even though juries are instructed not to draw a negative inference from the taking of the Fifth Amendment, sometimes they likely do.
And let me ask you this, in the current environment where issues are being pushed from the federal government to the state, and then we also have people pushing for sort of the original interpretation of the Constitution, how do those two play out in terms of whether the Bill of Rights will be affecting the state, the operation of state and local government?
All of the Bill of Rights now applies to state and local governments, except for three provisions. The Third Amendment that says the government can't force people to house soldiers in their homes. The Fifth Amendment requirement for a grand jury indictment in criminal cases. And the Seventh Amendment right to jury trial in civil cases. All the other Bill of Rights apply to state and local governments. There is nothing that the Supreme Court has done that indicates that the Supreme Court is going to pull back on that. Now, it is true that the court said that the issue of abortion is left to the political process and therefore likely to the states. But there's no indication whatsoever that the Supreme Court is going to lessen the application of, say, what we're talking about today, the Fourth and the Fifth Amendment to state and local governments. So in that sense, whatever change there's been with regard to abortion rights hasn't applied here. Now, you point to something that's quite crucial, and that's the Supreme Court has increasingly come to embrace what's called originalism. Original is the view that the meaning of a constitutional provision is fixed when it's adopted and can be changed only by amendment. In 1987, Robert Bork was defeated by the Senate for a Supreme Court nomination because they found his originalist views unacceptable. Now, however, we have at least three justices, Clarence Thomas, Neil Gorsuch, and Amy Coney Barrett, who are self-described originalists. And at least some of the other conservatives, Samuel Alito, Brett Kavanaugh, are very sympathetic to originalism. As I say, originalism is the view that the meaning of a constitutional provision is fixed when it's adopted, and it can change only by amendment. And that's part of what I think underlies the Supreme Court's decision in overruling Roe versus Wade. It's what the Supreme Court has pointed to in expanding Second Amendment gun rights, in expanding protection of free exercise of religion, and the like. And this comes up in Fourth and Fifth Amendment cases as well. There was a Supreme Court case a year ago, Lang versus California, that involved if police are chasing someone, can they go into the home when the underlying crime is a misdemeanor? And Justice Kagan, writing for the court, said, well, to find the answer, we need to go to whether that would have been seen in 1791 is permissible. Or there's another case, Torres versus Madrid, where there's the question of when is somebody seized by the police? Were the police shooting at the person enough for seizure? And Chief Justice Roberts said, we have to look back to 1791. So I think this is a court that's increasingly, in all areas, looking at history. I'm very critical of that. I don't think we can know what the framers thought. I think they lived in a vastly different world than ours. I'm worried that if we really were to follow originalism, a case like Brown versus Board of Education would be impermissible. Can I do a moment of a shameless plug?
Please.
I have a new book coming out. The publication date is next Tuesday. It's titled Worse Than Nothing, The Dangerous Fallacy of Originalism, that is exactly on this topic that you've asked me a question about.
Well, and what we will do, Professor, is when we send a thank you to everyone for participating and a link to the video, we will include information. If you send us a link about the book, so
sure.
that
I'm embarrassed to mention it just so fits with your question.
You know, listen, you're not the first author who talks about their books. You should be proud of the fact that you've done that.
Thank you.
Now, all right, I'm going to try to give you a rapid fire because we've got so many questions. And our listeners are so interesting. So here we have one who's thinking about, this is the anniversary of Nixon's acceptance of Ford's pardon. And did Nixon admit guilt by accepting that full and absolute pardon? And does an acceptance of a presidential pardon demonstrate that someone was guilty?
No. When a person accepts a pardon, they've accepted the pardon. They're making no confession with regard to guilt. So Gerald Ford said he was pardoning Nixon, and this, of course, was in 1974, for the good of the country, his healing. And Nixon accepted the pardon. But the law does not regard that as an admission of guilt.
Okay. And one of our listeners says, okay, if we're talking originalism on the high court and the Second Amendment referred to muskets and militias, why do we not hear about that in the context of originalism?
I think there's a strong argument that says if we were just to be originalists, then arms meant the arms that existed in 1791. Justice Thomas addressed that in the most recent Second Amendment case, New York State Rifle and Pistol Association versus Bruin on June 23rd of this year, where he said the Second Amendment is no more limited to the weapons that existed in 1791 than that the First Amendment is limited to the media that existed in 1791. In other words, saying we apply free speech to radio, television, the internet. Well, so likewise will we apply the Second Amendment to weapons that didn't exist then. That's what Justice Thomas says.
And tell us this, are there special circumstances for searches in the schools, particularly cell phone searches?
Okay. I love going to speak to students in schools. I've often gone to 8th grade classes because they study the Constitution in California. And that's the question I get most frequently. Yes, for schools, there's a special rule. It comes from a case called New Jersey versus TLO. And there the Supreme Court says that the school can search a student's backpack or purse with reasonable suspicion. They don't need probable cause. So that standard that I mentioned from Terry versus Ohio, that's nowhere found in the Constitution, comes up in the school context. For phones, I think it's different, though. I think, again, there'd have to at least be reasonable suspicion to look onto a student's phone, maybe more than that. There's an important Supreme Court case, Riley versus California, that involved the police arresting someone and then looking at the contents of the cell phone. And the Supreme Court ruled that cell phones contain the privacies of life. We put medical information there, we put financial information there. And so the Supreme Court has said, in order to search somebody's phone, there's to be a warrant based on probable cause or an emergency. And I think that the court's likely, even in the school context, to say, to look at the contents of someone's phone takes a warrant based on probable cause or an emergency.
Okay, that's great. All right, two more. The shadow docket doesn't get as much media play, and so many of those cases are not that well known. Have there been Fourth or Fifth Amendment cases on the shadow docket that we should be aware of?
No, the shadow docket refers to matters that come to the Supreme Court for an emergency ruling. And shadow docket may have negative connotations. And we should be clear, as long as there's been a Supreme Court, there have been instances where people have wanted to come for an emergency ruling. Where this often occurred was when there's somebody who's been sentenced to death and wants a Supreme Court to intervene, often at the last minute, they come for an emergency order. Well, that's the so-called shadow docket. And these are orders by the court without briefing and oral argument. There's no doubt there's been a tremendous increase in such rulings from the court. Law professors William Body at the University of Chicago, Stephen Vladeck at the University of Texas have documented the increase in rulings on the so-called shadow docket. It's interesting. I can't think of ones about the Fourth and Fifth Amendment. There's certainly been ones about many other areas, about abortion laws. There have been rulings with regard to immigration matters on the shadow docket, certainly a lot of death penalty cases, a lot of COVID religion cases, but I can't think of Fourth and Fifth Amendment cases that have come up that way. And it might be that Fourth and Fifth Amendment issues arise in two contexts. One is if a criminal defendant is being prosecuted and says the evidence was gained in violation of the Fourth Amendment and should be excluded, well, that case is going to have to come to an end before it can come to the Supreme Court. You can't go to the Supreme Court for an emergency ruling in the middle of the case on it. And the other is suit for money damage against police officers who violate the Fourth and Fifth Amendment. That too would likely get all of the way through the system before it comes for the court. So you're less likely to see an emergency ruling.
Got it. And you've talked about both police custody and under arrest. What's the difference?
The Fourth Amendment, and I read at this beginning, uses the word seizure. And a seizure occurs if a reasonable person under the circumstances would not feel free to leave. There are different forms the seizure can take. One is an arrest, and that requires probable cause. The other is just a stop, and that only requires reasonable suspicion. Both are seizures. Both are, in essence, the person's freedom of movement is restricted. One has to rise to a higher level, probable cause. The other is a lower level, reasonable suspicion. And the Supreme Court has never given us clear guidance for how to decide, is it a stop or is it an arrest? It'll go to the duration of how long it is. It'll go to where the person is held and the like.
All right, now, trying to think about which of the various questions could we, one of our writers is concerned about the question around the Presidential Records Act, believing that asserting that the president has the authority to declassify anything he wants to declassify, and that President Trump declassified the information, and the FBI therefore should not have had the right to come in and make that seizure.
First, none of the three crimes that were alleged as the basis for probable cause turned on whether the documents were or were not classified. I'm not sure that the media adequately reported this. So even if they had been declassified for the specific crimes that were the basis for probable cause that led to the search, didn't matter. Also, whether President Trump indeed declassified the documents is in dispute. Trump supporters have said Trump has alleged that he declassified. Others dispute that. But for the particular crimes that were alleged and the three statutes that were alleged to be violated, none of them turned on whether the documents have been declassified or not.
Got it. Well, obviously, this is an issue that will continue to perplex people. And so those who are interested in the book will get the information. We thank you so much, Professor, for your time, for your talent, for your scholarship. And we have certainly been schooled as we came forward. We want to thank our listeners, as always. We kind of say this is the NPR moment when we remind people that these are available only because of the generosity of members and friends, donors to the United States Capitol Historical Society. Thank you very much for your contributions. Coming ahead, we invite you to join us at the Library of Congress Book Festival, coming up on this Saturday at the Convention Center in Washington, D.C. It's an amazing festival of books and authors. And so we will be in the exhibitor booth on the lower level. We hope you'll stop by and join us. And as we continue this series on the amendments to the Constitution, we invite you to join us in 2 weeks for our next segment, which will be on the 6th, 7th, and 8th amendments, commonly called the trial amendments. And these are the amendments that guarantee our right to a speedy trial, a jury of our peers, and if convicted, protection from cruel and unusual punishment. If we know our history, 2 years before the Constitutional Convention, Benjamin Franklin endorsed the maxim that it is better to 100 guilty persons should escape than that one innocent person should suffer, as Professor has shared with us. It is in this spirit that the United States of America protects the rights of the accused, presuming them innocent until proven guilty. But what are the origins of this belief and its importance? Our featured guest for the conversation is the Sterling Professor of Law and Political Science at Yale University, Akil Reed Amar. Professor Amar has won awards from the American Bar Association and the Federalist Society, and is often testifying in Congress for both Republicans and Democrats choose him as their witness. His scholarship has been featured on Fox News by Tucker Carlson, on MSNBC by Brian Williams, and so he should be quite an interesting scholar. So we hope you will join us as we move forward. Thank you again, Professor. Thank you all for being here. We appreciate your time, your talent. Have a wonderful Labor Day and be well. Goodbye.